acknowledge on the record that you do not have to object again. So once the judge states to you on the record, counsel, I acknowledge you're objecting to this form of evidence, and now note that you have a standing objection, then I think you're pretty safe with the appellate court going forward that it'll be deemed that you had objected. Okay, let's talk about reasons not to object. So, you know, I've seen some trials where usually they're newer attorneys and they object continuously throughout the entire trial over very minor and trivial things. And frankly, for the court and even for the jurors, this can get annoying. And so my rule of thumb and recommendation would be if it's a minor issue, then no harm, no foul. Don't keep objecting over minor trivial things, because you have to be concerned about how the perception the court may have, or the jury, that you're basically kind of being an obstructionist. And so this kind of leads to my trial tip. Be mindful how the jury perceives your objections. If you continually object regarding minor issues, the jury may become irritated and perceive you as an obstructionist, what I just said. So this is more of a tactical question. You may need to object initially to set the tone, which is one of my recommendations. So if you run up against an attorney, it's kind of what I call cheating. In other words, let's say the question is leading questions, and the attorney always is continually throwing leading questions in during their direct examination on substantive issues, in other words, important issues. You know, it might be wise to object a few times right at the beginning, kind of set the tone, because it is an important issue. So these, again, are tactical issues for you to decide, should you object or shouldn't you? If it's an important issue, the evidence is prejudicial to your case, you probably should object. If it's a minor issue, no consequence, consider not objecting and just let it go by. All right. So now that we've kind of covered some of the procedural aspects of objecting, let's talk about the 18 most common trial objections you're going to run across. And remember, this doesn't necessarily have to be a jury trial. It can be a trial before the judge or a bench trial. It could be a family law hearing, any kind of evidentiary hearing where testimony is taken and it's contested. Most of these objections will be applicable. And the other thing I would advise is that you commit them to memory as much as possible. So you remember my trial tip at the beginning. If not, have a cheat sheet in front of you to help you remember the most common objections, because many of these objections will have to be made very quickly. There's not a lot of time as testimony's flowing. A lot of witnesses speak quickly. Testimony comes in rapid succession. So you have to be totally up to speed on the potential objections that could come into play, and also how to respond to them if you're the opposing party. All right, so let's get to the 18 most common objections, and I've kind of ranked them essentially in the order of what I see from the most common kind of to the least common in the order generally. All right, let's talk about objection number 1, relevance. This is by far the most common objection made in a courtroom in any kind of trial or hearing. And the definition of relevance is set forth in evidence codes, and it's basically similar in all jurisdictions, but evidence is relevant if A, it has a tendency to make a fact more or less probable than it would be without the evidence, and B, the fact is of consequence in determining the action. And, the corollary to that is irrelevant evidence is inadmissible. So now, relevance is just one of those things highly subjective, depending on the type of case and the facts of your own particular case. So there's no recipe I can give you about how to determine if evidence is relevant. This is kind of it when you see it kind of thing. But generally, if you're listening to testimony and suddenly your opposing attorney asks a question that seems to be out of left field, that seems to have really nothing to do with the issues of consequence, then you just need to make the objection on relevance. And a lot of times, again, the judge may or may not respond to opposing counsel for a response. If it's very obvious, the judge may say, sustain, move on, counsel, and that's the end of it. So relevance is by far the most common trial objection that I've seen in the courtroom. The second most common one is vague and ambiguous. And generally this is where counsel just puts together a poorly worded question. And it's unclear. It could be with a double negative. It could be full of inconsistencies. It's just a very confusing, unclear question. And again, this is, you'll know when you see it. We have to be paying attention. And when you hear your opposing counsel make a question that seems that you can't even understand, or a lot of times you take a clue from the witness who looks perplexed, an objection, Your Honor, vague and ambiguous, would be an opportunity to object there. The question is poorly worded, confusing, for example, double negative. And here's a trial tip kind of in that same vein. Be particularly alert when opposing counsel propounds a long-winded question, because there's a good chance that it's vague and ambiguous and is probably also compound. So if you hear your opponent over here make a long, drawn-out question, you should be on high alert that it's vague and ambiguous. It also could be a compound question. It could be 2 or 3 questions all rolled into one. And you're kind of the protector. This might be your witness on the stand. So you're kind of protecting the witness from these types of questions. The way to do it is objection, Your Honor, vague and ambiguous. The third more common objection is speculation. And essentially, again, this is where you're asking the witness to make a guess. It can also go the other way if the witness is not necessarily the question being asked. It could be answer being given could require a response. So if the witness responds and says something that appears to be a guess, speculation, conjecture, not based on what's called personal knowledge, then again, the objection would be appropriate. Objection, Your Honor, speculation. And you'll notice that some of these objections apply both to the question being asked, so it could be something the way your opponent has phrased the question, but it could also apply equally as well to the answer given by the witness. It could be, speculative. All right. So number 4, leading question. This is very common and often mostly occurs when the direct examination is going on and an attorney asks a leading question during direct examination, which is generally prohibited. However, I want to make a caveat here. If you saw my video on cross-examination, I pointed out that often leading questions during direct are perfectly appropriate for non-contested issues. And many judges will allow that because you need to get the case moving forward. the leading question is objectionable during direct examination if it goes to a highly contested issue or fact. In other words, the meat of the case. Something is very important. If counsel starts giving leading questions, then the appropriate objection is objection, Your Honor, leading question. And here's a trial tip related to leading questions. Anticipate when opposing counsel may be tempted to use leading questions and object at the first instance to set the tone. If opposing counsel knows you are willing and able to object, they tend to police themselves better. And you'll see, if you've done many hearings or trials, and you're sitting there hearing counsel do direct examination, and it's getting to a very highly contested issue, you should be on alert then for the possibility of a leading question. And you can almost sense that counsel's building up to a leading question, and so that's where you really need to jump in there and object to it. And remember, the answer is, the procedure is if the witness answers before you can object, you may also be required to make a motion to strike. Another common objection made by attorneys is lack of foundation. Objection on a lack of foundation. Now, actually, this is not necessarily a technically correct objection. Lack of foundation can mean many things. It means some foundational requirement has not yet been fulfilled before evidence could come in. Now, the most obvious example is authentication. So, for example, if your opponent's counsel has been asking the witness questions and hasn't laid out a foundation of authentication, or that the witness was there to personally observe it or has personal knowledge, then they fail to lay out that preliminary aspect before the evidence is admissible, and therefore a lack of foundation objection may be appropriate. So my trial tip in this regard is the lack of foundation objection is often made incorrectly by not stating the specific foundational element that is lacking. For example, personal knowledge or proper authentication. So actually, if your opposing counsel has failed, for example, to establish personal knowledge, and one example is, let's say the witness is talking about a car accident in an intersection, a traffic collision, and your opposing counsel might be asking questions that seem to assume that the witness saw it, but the witness hasn't actually said yet that they are a recipient witness. And then the witness goes on to say, yeah, the red car ran the red light. You might say objection on a lack of foundation personal knowledge because your opposing counsel hasn't yet established that the witness actually saw it happen. And sometimes I've seen it occur where the witness will testify on direct examination as though they had seen it. Yeah, the red car ran the red light. And then on cross-examination, it's elicited that, well, I didn't actually see the red car run the red light, but that's what the officer told me afterwards, or that's what I assumed. I just put two and two together. It seemed obvious to me, but there wasn't any personal knowledge. So again, this is where you can have a lack of foundation, lack of personal knowledge in that regard. And that kind of brings me to number 6 here, which I've kind of already tipped my hand on, and that is lack of personal knowledge. What I've just described is this is generally where the witness doesn't have any personal knowledge, hasn't seen it in him or herself, and that's a requirement for lay testimony generally. The rule is basically all witnesses must have personal knowledge. The exception are allowed to give their opinions based on other information and hearsay. But most lay witnesses, if they're going to come in before and explain to a jury, what they saw at the scene of a traffic collision, they have to have personal knowledge. They must have actually perceived it, heard it, with their own eyes, sensed it, personal knowledge. In other words, have been a recipient witness. Okay, another common objection is non-responsive. And in my video on cross-examination, if you haven't seen that yet, you should watch it. But this is often a very common objection during cross made by the examiner on cross-examination when the witness is not responding to the question correctly. So the examiner, using leading questions, may have asked a question that only required a yes or no, and the witness was non-responsive said yes and then added more information. In other words, the witness responded to more information that you required. Or sometimes on leading, you'll ask a question that requires a yes or no, and the witness dodges the answer and just adds their own information. The light was red, the light was yellow before you entered the intersection, wasn't it? And the witness said, well, the other car ran it. In other words, the witness never even answered your question. Then the objection would be objection, Your Honor, non-responsive. The non-responsive answer could apply to any witness that basically doesn't respond to the question. So be alert for that. Number 8 is basically just compound. It's basically a compound question is basically 2 questions rolled into one. It would also probably qualify as a vague and ambiguous question. So be alert for that. I've already given you the trial tip, about that. One trial tip I forgot to mention regarding non-responsive is the non-responsive objection is a good method to keep the witness in check during cross-examination with one caveat. Ensure the question only calls for a yes or no answer. If the question is poorly phrased or cannot be answered without explanation, the court may overrule the objection, making you look like the bad guy. Alright, let's go to number 9, hearsay. Now this isn't a video on hearsay. You can take a whole law school class in evidence on hearsay. But it comes up fairly frequently during a trial. You'd be surprised how often. And so basically, just be alert that there could be hearsay question, that could require hearsay answer. And again, one of the keys is that you object before the answer is given. So you don't have to, the jurors don't hear it. Because I think one court famously said, you can't unring a bell. So once the jurors have heard it, even if the judge said disregard that, well, they heard the answer. And so now what do you do? And so I've kind of come up with my cheat sheet for hearsay, and you should have it at trial counsel, is just remember what the elements of hearsay are. This is the questions you have to go through in your own mind is there a statement? Because only statements of witnesses or people are hearsay. Is it being offered for the truth of the matter? And there are a lot of reasons that it might not be offered for the truth. If it's not being offered for the truth, then the next inquiry by the court will be, then what's the relevance of the non-hearsay purpose? And then if it is being offered for the truth, the next question to determine is there an applicable exception to the rule? Because many evidence codes have laid out very carefully the noted exceptions to the hearsay rule. So there's a lot of information here. You really need to be up on it if you're a trial lawyer, because it does come to play fairly frequently right in the middle of trial, things you haven't even thought of, where the witness said, where there could be hearsay elicited. You need to be prepared to respond to that. Number 10 is an objection to improper lay opinion. So you see this from time to time, and this is where the witness either is asked a question that requires to make an improper lay opinion. In other words, an opinion that is lay witnesses are not permitted to make, or the witness gives something that is more in line with an expert opinion, or it's based on speculation. So now, lay opinion, in other words, the witness is a non-expert. They can give their opinion, they're not prohibited from making any opinion. And many of the rules of evidence do allow lay opinion if it's rationally based on the witness' perception and helpful to clearly understand the witness's testimony or in determining a fact and issue, and not based on scientific, technical, or other specialized knowledge within the scope of Rule 702. Now this is from the federal rules. Rule 702 describes and talks about expert testimony. So this sometimes is kind of interesting about how far witnesses can go in making lay opinion. And some of the courts, I did think it's important to think about some of the language, what courts have said about lay opinion. And here's what one court said. The opinion rule for non-experts merely requires the witness express themselves at the lowest possible level of abstraction. Whenever feasible, concluding should be left to the jury. However, when the details observed, even though recalled, are too complex or too subtle for concrete description by the witness, he or she may state his general impressions. So a good example of this is a witness being asked about intoxication. And the witness may say, yeah, he looked like he was drunk. Now, when a witness says a person looks like they're drunk, intoxicated, courts have also held angry, upset, sad, even one court I think said crazy. Now those are all opinions if you think about it, but they're so subtle that it's hard to distill it down any further. We all know from looking at someone whether they look sad or happy or upset, or we often have seen people that look intoxicated, but to try to describe that to some third party and have that make sense, too difficult. So those are proper lay opinions. And so it often comes up in where it can get a little bit gray is if the witness makes a lay opinion about intent. So, for example, I think a witness could say, yeah, he looked really mad, or he was acting frantic, or the witness was hysterical. But what the witness can't go is to try to make an opinion about what the actor was thinking. Yeah, he was angry, and he looked like he was going to kill him. See, now you're kind of crossed over into an opinion about the mental state of the actor that's being described. And the judge might sustain that, because now that's really almost into speculation. That might be the realm of expert testimony. So you generally, lay opinion can't really go into speculating or forming an opinion about what someone else was thinking. You can describe how they acted, what their appearance was, if they looked drunk, upset, angry, hysterical, but you can't go into what their actual mental state was. That then would be improper lay opinion. That's kind of a short explanation of that. Another objection is called assumes facts not in evidence, and this is generally when some preliminary fact has not been established. So this will occur when your opponent is asking questions to a witness, and the opponent's questions seem to assume, for example, that the witness was personally present at the scene of the accident and saw it. You know, so the first questions of a witness might be, now when the red car ran the red light, where were you seated? Or, where were you standing? Well, objection, Your Honor, that assumes facts not in evidence, because the witness has never testified yet that he or she was even present or had any personal knowledge. You can see how some of these objections kind of tie together a little bit. Assumes facts not in evidence could also be similar to no personal knowledge. Number 12, misstates the evidence. This is less common, but it generally occurs often when an attorney asks a question to a witness and the attorney might misstate the facts. For example, yesterday you heard Officer Jones testify to A, B, C, or D, and the attorney just misstated what was said. Could be an example. One thing I've noticed that can get confusing even for jurors. So a lot of times on cross-examination, the attorney will ask the witness what they said previously at the same hearing at an earlier time. Say it was a break. The witness testified yesterday and now is back on the stand for cross-examination, and the witness will ask, and the attorney will ask the witness, do you recall yesterday when you testified that you thought that the traffic light was yellow? And so again, what's happening is the attorney is summarizing or paraphrasing what the witness purportedly said the day before. And a lot of times the attorney gets it a little bit wrong or puts a little spin on it. And so this is where you, sitting there listening to it, might want to objection or misstates the evidence, because that might not be exactly what the witness said yesterday. And sometimes words are important, obviously, in a trial. Words can have great importance in a trial of how exactly things were said. Number 13 is argumentative. Now, an argumentative question usually is made by your opponent during cross-examinations, where you see it most often. And it's basically an argumentative question is one that really isn't a question asking for any legitimate response. It's really making a statement or an accusation, kind of a point, so to speak, for the jurors. I recall there was one case where the defendant's fingerprints were found on the safe and the charge was burglary, and the defendant was on the stand. The prosecutor asked something like, well, are you saying that the fingerprints are lying too? Now, obviously, that's not a real question. That's just an argumentative question to make the point. And so that would be one example. So if you feel that your opposing attorney's questions are getting out of line. They're not really asking for facts or evidence. They're trying to make a point to the jury. The appropriate argument is, the appropriate objection is argumentative. However, my trial tip is a question is generally not argumentative merely because the cross-examiner turns up the heat and confronts the witness with, say, an inconsistency or suggests an improper motive. So merely because you're aggressive in your cross-examination, or you may be implying or you're actually accusing the witness of being untruthful, that is probably not argumentative. That's just good, aggressive cross-examination. All right, number 14 is narrative. Narrative generally occurs during the direct examination where the witness is basically allowed to just ramble on. And you'll kind of note it. Basically, direct examination should go question, answer, but not little short bits and pieces. The witness should be allowed to give, some narration. Otherwise, it'd just be too choppy. But when the witness keeps going and maybe even digresses or goes off some tangent, then the appropriate